joining us this afternoon, Mike Tew of the Institute of International Legal Studies of the UP's College of Law. Welcome to Storycon. Attorney Tew, thanks for joining us.
Hi, sir.
Thanks for having me.
Salamat, attorney.
Good afternoon.
Attorney, lots to dissect here. Let's begin with the pre-trial initial proceedings nung Friday. What did you make of it? In particular, the part where former ES Medialdea gave a 4-minute manifestation saying that this was all an extrajudicial rendition, aka kidnapping of Duterte.
Right, so the initial appearance went exactly as it should have gone, quick, to the point, and just consistent with the purpose of familiarizing with the accused, reading the charges and reading the accused their rights, right? So I would say that the initial statement is a little bit unusual, out of order, which is something that we're used to here, but they really are careful about those statements, although of course it was still the case that they gave him the time to air those out, but it was an inappropriate statement for that kind of proceeding, I would say.
Attorney, why is that? Bakit siya unusual and why is it inappropriate?
Because that was not the time to raise those arguments. That time is the confirmation of charges. The initial appearance, as the name suggests, is really initial. It really is just to recognize that the accused is there, confirming the identity of that accused. So it was not some kind of an oral argument where you could raise those things, although we can still say that there was still the chance given to the defense to raise those statements. So it was all good in the end.
Pero from your...
May pahapyaw din sa ICC. I remember this particular part where Medialdea said, you're looking at two troubled entities, and I'm paraphrasing here, that struck a deal, the incumbent president and a troubled legal institution in need of a legal show. Of course, he didn't name what it was.
Yun nga yung itatanong ko, attorney. From your vantage point, tama ba yung ginawa niya na binanatan niya yung korte na hahatol sa kanyang kliyente? Baka hindi kabisado ni ES Medialdea kung nasaan korte siya.
That's correct. I didn't think it was very smart to say that because the court is very protective of its integrity and also its legitimacy. But also, I was thinking as I was listening to that maybe the court wasn't the audience for that statement, so they just took the opportunity to speak to somebody else through that medium.
That's a good way of looking at it.
Price catch daw nila si Duterte because may problema talaga ngayon ng ICC, no? Pero kung opening statement yun, di ba, attorney, standard ba yun sa Pilipinas? Kasi usually may ganyan din sa atin, di ba? Meron kang opening statement tapos saka na lang maghihintay, or does that happen during the trial?
Sa atin wala talagang opening statement din kasi wala naman tayong jury. Usually nagpa-function yan kung may audience ka like a jury. But lawyers do that as like in the form of manifestations if they want to emphasize a point. And that can happen anytime. That can happen in pre-trial or during any of the dates for trial. Usually the judge just notes all of those statements, but because you're not speaking to a gallery there. So even in our courts, while lawyers do that routinely, they hardly matter much unless you are before, let's say, a court where you're making an oral argument, let's say, before the Supreme Court.
Kung ikaw mag-opening statement, Ed, anong sasabihin mo?
Kailangan ko ng chinelas tsaka ng medyas.
Hindi na pag-usapan kanina yung pangangailangan sa kulambo. Hindi na banggit eh.
I have another question there.
Baka kami nagdala na.
Kasi over the weekend, ang sabi nito ni Harry Roque is that, at least over the weekend pa to, they plan to file a manifestation questioning the jurisdiction of the pretrial chamber and the ICC, of course, in general, before September 23. I'm wondering how that would work, considering that, am I getting this right? The ICC already has acquired jurisdiction, the pretrial chamber already has acquired jurisdiction, and therefore, would it or could it just let go of that jurisdiction at this point?
Yes, they could look at the question of jurisdiction again kasi yung una pong nag-raise ng jurisdiction is the state, no? Yung Pilipinas yung nakipagtalo about jurisdiction. Pero the Rome Statute does also give the arrested person, or in this case, after the confirmation of charges, the accused, an opportunity to challenge the jurisdiction again kasi may ibang aspeto yung jurisdiction, yun yung jurisdiction over their person. So dito kasi may particular na tao na na-identify. So they can raise the question again.
Attorney, ano yung chances na makakuha siya ng interim release batay sa inyong pagkakaunawa dun sa rules ng ICC?
Sa aking pagkakaunawa, kasi fact-intensive yung analysis ng interim release. No? So, siguro yung premise ay i-check niya kung meron pa ba yung conditions kung bakit siya nag-issue ng warrant of arrest in the first place. And merong mga circumstances kung bakit necessary yung warrant of arrest. Isa na doon yung para hindi makapag-interfere yung taong aarestuhin doon sa investigation or doon sa kalagayan ng mga witnesses. Another is para hindi mabigyan ng pagkakataon yung arrested person na mag-commit pa ng further crimes. So kailangan siyang i-hold in detention. So if the court is satisfied na wala yung mga risks na yon, and maybe also flight risks, no? If wala yung mga risks na yon, then it can consider granting interim release, but also with conditions, with or without conditions. So sa akin talagang importante kung ano ba yung mga circumstances that the court can consider in this release. And we can see in this environment that the court might also consider ano ba yung potential for, let's say, violence, potential for this person to come back and face the court if ma-release, no? It's really not helping that the rhetoric around his detention is this way, because that's added consideration for the court to say that it might not be very wise to grant that interim release.
Yung request niya para ni Vice President na maging legal counsel, ganun ba ka-tactical yon? Di ba dapat mas stricter yung rule sa legal counsel? Pero kung openly, ang gusto lang namang nila ay makapasok, makadalaw. No? From your vantage point, ay kung ba yun? Compelling or posible? Based on the rules mismo at saka criteria ng ICC for what a legal counsel should be?
Yes, so yung rules of procedure ng ICC, ng Rome Statute, ay medyo mataas-taas yung bar for who can be counsel or even assistant to counsel. And they need to be able to demonstrate na meron silang kaalaman doon sa international law or criminal law in general, kasi it's really a criminal trial as well. So kailangan i-establish yan, no? Merong isang mechanism which is ito yung magpa-file ka ng power of attorney at the earliest opportunity if you were the choice counsel of the accused. Pero I don't think that it's going to be a very smart defense to put in lawyers who don't know the practice of the court. So this was a smart move for them to hire a lawyer who's really been practicing before the court and is familiar with the procedures. Kasi nakita natin nung initial appearance, the court or the chambers really have very little space or leeway given to things that are out of order or that are not within the procedure. So perhaps I think, and if they really just want to get inside, there are mechanisms for that. In fact, the previous time they were able to see from the gallery. If they're not going to advise anyway, especially if the advice is not going to be helpful, then I don't think that they should be sitting in those chairs. That could end up just prejudicing his case if they get it wrong.
Sir, I was speaking
Ano
kanina
yung
to...
reklamo ng yung reklamo ni E.S. Medialdea, extrajudicial rendition It's similar to extraordinary rendition, no? Sa tingin mo, based on experience around the world, may basihan ba yung sinabi niya?
Hindi, kasi yung mga kaso ng extra rendition na nakita natin, hindi natin narinig muli kung nasa na yung tao na yon. Di ba yun yung nangyari after 9/11, madaming kaso na dinadala sa ibang bansa. Para ito, we know exactly where he is. We know exactly that his rights are protected. So it's not the case of extra rendition. Ito yung kasi yung tinitake out mo from the protection of the law yung tao. It's extraordinary rendition. But here, there's an entire body of law that protects this particular person. And in fact, the court guarantees those rights. So it's not
Pero
extraordinary.
yung pagkagamit niya, di ba, in the sense na pinadala ng Pilipinas dahil hindi natin gustong, kasi sa US ayaw nilang pinapadala nila sa ibang bansa para ma-torture daw, yun ang sabi ng mga kritika, para ma-torture sa ibang bansa yung gusto nilang questionin. Ito naman, dahil wala daw tayong capability, Tinapo natin sa dahig para sila yung mag-try. Meron bang basis yung ganong argumento?
Hindi rendition
Sa tingin,
yun.
That's right. Merong basis yon kasi even though ilabas mo dun sa argumento na may jurisdiction ba yung ICC, no? Yung Pilipinas, meron siyang soberanya at discretion to act, to cooperate even though it's not formally part of a regime, no? Ibang tanong na yun kung under our domestic law ay papasa ba yun. Pero in terms of whether the Philippines can choose to comply or cooperate with an international institution, it can very well do that without joining a treaty. In fact, in the entire corpus of foreign policy in the Philippines rests on the president or in the president's hands. So kaya namang gawin yun ng bansa, no? Or ng estado bilang voluntary action.
Sir, I was speaking kanina to Atty. Estelito Torion, one of the counsels of the former president, and of course Bato de la Rosa. He filed on Friday a supplemental petition for motion for reconsideration dun sa kanyang TRO, which was earlier denied by the Supreme Court to put a stop to the expulsion of the former president. He's still arguing na Article 59 of the Rome Statute still covers country or states that are not party anymore to the Rome Statute, including the Philippines. And that kailangan pa rin daw dumaan sa judicial process ang any expulsion or extradition or even surrender of any Filipino to another state or another tribunal abroad. I asked that kasi I also read a posting by Professor Alexis Medina, also to that same effect, na whether you call it extradition or surrender under 9851, you still have to go through a certain judicial process, and the executive cannot just unilaterally give you away to another country, another power, or another foreign tribunal without going to the court.
A local judicial authority, let's be clear. Dapat daw dumaan sa korte here.
Pero di ba, attorney, walang pakialam ang ICC ron. Ang mahalaga sa ICC ay nandun na siya. Kung paano siya napunta ron, wala na silang pakialam. Basta itatrial siya. Parang yung issue na yon ay issue dito sa ating bansa.
That's correct. In fact, dun sa forum na dinaluhan natin with Judge Raul Pangalangan last Friday, nabagit niya na hindi tinitingnan ng court yung process of how you get to the court. But I would say also, even under the terms of Article 59, no, yung how the court has treated that provision in the past. So there's one case, the Ongwen case, where the court said that that provision in and of itself does not necessarily mandate a particular procedure. So even if we do concede na nag-a-apply yung Article 59, that provision gives the state leeway as to how it will structure its procedure in that surrender. So in fact, in that Ongwen case, satisfied na si pre-trial chamber na binasahan ng contents ng warrant, chinek kung siya ba yung identity, and then sinurrender si person. And in that case, ang nag-appear si Ongwen just before the Prosecutor General of a certain court. So hindi man lang huwes, and that was sufficient. So if we're going to engage with that argument, even under those terms of Article 59, it is likely that the procedure that had happened here will still be sufficient so that his arrest would have been valid and transfer is valid.
Okay. We'll leave that there. Thank you so much for your insights today. Attorney Mike Tew of the Institute of International Legal Studies of UP College of Law.
Salamat, attorney.
Thanks, sir.
Thank you, attorney.